further hearing in the appeal on Nuclear Decommissioning Authority and EnergySolutions.
Mr. Howell.
My Lord, yesterday Lord Mance referred to academic writings and asked whether there were any, having referred to them in a number of foreign languages. There is an English academic, or at least in English, an academic article about it, which we've provided by Professor Trumer, who's the Professor of Public Procurement Law and Privatisation Law at the University of Copenhagen. The relevant part...
it's like Träumer.
Träumer.
Which means dreamer in German, but I don't think...
Nightmare would be more appropriate.
Spelt differently, though.
Yes, it is spelled differently, I do accept that.
Anyway, the relevant passage is at page 159.
Thank you.
Come on, goes to the bottom.
Right.
It says, very recent case law from the Court of Justice of the European Union has addressed the conditions of damages, notably the case of Strayberg and Spiker. However, this case law appears to cause more confusion than clarity. He then makes the point at the end of the first paragraph from Strayberg, it would appear from the ruling that any breach of the EU public procurement rules in principle is sufficient to ground damages. And then if one drops down to the last paragraph, the subsequent ruling from the Court of Justice in Spiker takes a fundamentally different approach. And his conclusion at the bottom of that paragraph, if I can just begin the sentence beginning consequently. Consequently, it remains uncertain what the Court of Justice considers as the state of law in this area. Presumably, EU member states will uphold their different national approaches until the EU law limitations have been clarified in the case law of the Court of Justice. The next time the issue arises, it would be appropriate to address it before a grand chamber of the court. Anyway.
Oh, well, that's a percipient comment from your point of view. Yeah.
I'll come back to the question about reference, but as your Lordship will see, this particular academic found difficulty in reconciling the two.
Yes.
See, the next paragraph is relevant too.
I mean, the only other reference I should perhaps...
Does he tell us what's his position? Does he indicate?
Well, he seems to suggest that if he was reading it, Strabag suggests that it isn't sufficiently serious, whereas Spiker suggests it is.
So the only other reference...
But he says that that's a matter for the national discretion, doesn't he, to choose between them in the next paragraph.
Yes, I think he accepts it. If the remedies directive is to be sufficiently serious, it still leaves at discretion. Yep. The only other point about practice is on page 165 in the second paragraph under conclusion, where he says it's not clear if it follows from EU law that any violation is sufficient ground for damages or if a sufficiently serious violation is required. The question might still be left to the discretion. In national legislation, the dominant trend appears to be that any violation is sufficient, although there has been a movement in some countries, the Nordic countries and Lithuania, towards the requirement of sufficiently serious, at least when it comes to the grant of damages for loss of profit. Nevertheless, recent case law from Sweden and Denmark appears to overrule the requirement for sufficiently serious.
Is he more specific about that case law? Yes, he is. He's
he is,
in the text,
if one
yes.
waits through it. But
so we have to read through the article. Yes.
But I don't particularly want to take up time, but your Lordship did ask me about an
No,
academic
it's very helpful to have.
Can I return to the point which Lord Newberger was putting to me last night about the significance of the use of the word may in Regulation 47J? For your Lordship's reference, 47J is in Volume 1, Tab 2 at page 830.
Thank you very much.
Can I make 4 points about it? Firstly, whatever the use of the term may does, it does not confer any discretion. That is because the Remedies Directive confers a right to damages, not a discretion to award them. And that's so whether or not our case or the NDA's case is correct. Your Lordship will recall in Stat Gratz, the court referred to the right to damages in respect of damage caused by an unlawful decision at paragraph 41 of its decision. It's also itself referred to in the Chamber's ruling itself, which I don't think we looked at, but it's, if I can give your Lordship the page reference, is Volume 2, Tab 21, page 1484.
Thank you.
Secondly, if the Frankovich conditions are satisfied, there is again a right to damages in EU law.
Understand.
There's no discretion not to award them. That's plain from Brasserie de Pêcheur itself, which, again, if I can just give you the references, it's Volume 1, Tab 13, page 1142, paragraph 51. And your Lordships and my Lady may have noticed that it was because satisfaction of those conditions gave rise to a right to reparation that the court stated that the fault as such was irrelevant at paragraph 79, which is page 1145 to 146.
Thank you.
And the court in Spiker itself stated that the conditions gave rise to a right of reparation in paragraph 87 of its judgment. And again, can I just give you the references for that?
Yeah.
It's volume 2, tab 18, page 1355.
Thank you very much.
Now, the second point about May is that the NDA's case is that a power to award damages must not or may not be exercised unless the breach is sufficiently serious.
Yes.
In my submission, that cannot be extracted from the terms of the regulations. It seeks to derive a prohibition that something may not be done from a power to do something.
You mean it's reading may as may brackets only, close brackets, in
Yes.
circumstances of sufficient
Yes.
seriousness?
So it's trying to get a prohibition out of a power, and moreover, the prohibition, it suggests, is inconsistent with the terms of the power given. Could I just ask you to have it in front of your the regulation in front of your lordship, so you can follow what...
Page 830, yes?
Page 830, so you can follow the point I want to make.
Yes.
It's volume 1, tab 2.
Yep.
Your lordship will recall that yesterday I submitted that the breach is constituted by a failure to comply with the relevant domestic regulations or the EU obligation.
Yes.
If the NDA's case is correct, and that damages may not be awarded to an economic operator who has suffered loss or damage in consequence of the breach, that is to say, by reference to the event which is in the regulation, but only to one who suffers loss or damage as a consequence of a sufficiently serious breach. So what they're seeking to imply is a limitation on the extent of the power to award damages that is inconsistent with the terms in which it is conferred.
Well, is that right? I mean, if may is given its normal meaning, it always carries with it may not. Otherwise, it will mean must. I mean, is it really right to say that an argument against this construction arises from the fact that it excludes in certain circumstances, because that's inherent in the word may?
Well, can I deal with that point when I come to my fourth point?
Very well.
I'm not going to overlook it. The third point, if I may, is that this regulation 47J also applies to GPA operators.
Yes.
They have a right to damages once the contract is concluded, since correction is not then possible. And they have a right to damages that is not conditional on them being a sufficiently serious breach, because that is not a requirement of the GPA agreement.
Right.
Now, the fourth point, which I hope will address my Lord Newberger's point, is that the power to award damages needs to be read in its context. The regulations have already made a breach of the duty owed to an economic operator actionable by an operator who suffers loss or damage in consequence of the breach. That's the earlier part of the regulations, as your Lordship has seen. What regulations 47I and J do, so what the power, given those regulations, does is to give the court the power to give effect to the claim for damages for an actionable breach of statutory duty. So one has to read Regulation 47J, the power to award damages there, and also 47I too, within the context that the breach has already been made actionable. And so what the regulations do is give the court the power to award damages to give effect to that actionable breach.
So one comes back to the fact that it's quite striking that it's may rather than must.
Yes. The reason,
because, sorry, you were going to say, yep.
No, I shouldn't have interrupted you.
No, no, please, you were going to answer my question.
Well, why it's there. The reason why the must is there are two reasons for must in 47J. The reason for 47.2a and b must is because the amending directive introduced a specific obligation saying that this is what the court must do in those circumstances. So that simply gives effect to the amending directive. The D, must not order any other remedies, is giving effect to the option in the remedies directive that the member state has to, once the contract is concluded, to say that the only remedy available is the remedy of damages. So the use of the term must can be explained in those specific ways.
Why not must in C?
Exactly.
Sorry, Madam.
Why not must in C, if your submission is correct?
Well, one reason maybe is that if you have A and B, you may not need to award damages if you've gone down A and B. But my Lord,
why is
None
that?
will have been suffered.
what I haven't done, which probably may have limited usefulness, is to look where enactments confer an actionable statutory duty, whether under the health and safety legislation and so forth.
The problem is more fundamental than that. It's not just the word may, it's the language which follows it in subparagraph C. Because taken together with the word may, that envisages that there are some circumstances in which loss can be shown to have flowed from a breach of the regulation, but damages may not be awarded. Now, if, as you, to my mind, rightly say, this isn't a question of discretionary award of damages, it follows that there must be some principle for deciding in what cases damages are awarded and in what cases they aren't. And if there is a principle, where is this principle to come from, if not from a well-established doctrine of EU law such as Frankovic?
Well, my Lord, in answer to your Lordship's question, your Lordship, in my submission, is adopting a too narrow approach to the use of the language in the regulations. As I say, when one looks at the structure of the regulations as a whole, what it provides is that there's an actionable breach, and this is the consequential power which the court has to enable it to give the remedies for that actionable breach. Now, in my submission, given that there is a right to damages, what your Lordship is seeking to suggest is that there must be some principle upon which it has to be exercised, but that assumes that there's some discretion. If there is a right to damages...
It assumes there's a discretion. It simply assumes that there are rules which may result in damages not being awardable in some cases. The question is, what rules and what cases? I mean, you say there's a right to damages. In general terms, there is a right to damages, but it doesn't follow that every kind of damages will necessarily be awardable.
No, I appreciate that. What is actually happening, sorry if I may say about the general structure, is the reason for making it an actionable breach of duty and giving the power to award damages is effectively to create the tort of a breach of statutory duty, which brings in all the means by which you can identify how damages be estimated, the principles on that basis. So what you'll be looking at about the power is the principles upon which you exercise the power the court has in a case for breach of statutory duty to award damages. Those will include things like remoteness and so forth, and other aspects of how you measure tortious damages, for example, what the measure is and so forth. In my respect, if you look at the basic scheme of that provision, that is what it's intended to do, and indeed, I mean, that's how it's not an answer to your Lordship, but that's always how it's been interpreted in the courts. The point about sufficiently seriousness, I think it's the first time it's ever been raised, is in this case, since these regulations, this form of regulation came in 1991. So although I think what your Lordship is looking for, if I may say so with respect, is placing far too great an emphasis on the use of the word may. I appreciate that there's a contrast, which I've tried to explain between may and must, but it places too great a weight on the term use may without regarding the context in which it's situated within the...
The flavour I'm getting is that you're saying that the draftsman draftswoman, may have put in the word may rather than must because of a concern that otherwise any loss or damage which otherwise might, according to domestic law principles, not in fact be recoverable, was to emphasise that you couldn't just say I've suffered loss and damage, therefore you must award me damages. The court had to carry out the normal damage exercise.
Yeah, and what it was,
and bear in mind all normal defences which would be available, remoteness, mitigation, stoppel, anything else.
yeah.
And it was cautious, and we mustn't place too much weight on the mere fact that it has may rather than must.
My Lord, yes. And
Isn't that, though, doesn't that mean that your argument on 47C is ill-founded, because you suggested that the primary right of action was in 47C? If so, then any loss or damage ought to be recoverable. And now you're saying that you said 47J was intended to give effect to 47C, but now you're saying it's intended to give effect to something else.
well, with respect, I think that's not the way I was putting it, my Lord. The way I was putting it is, if you look at this it's easier to see it in the earlier regulations, but if you look at this regulation, the basic scheme is to make the breach of duty actionable and give the court the power to award damages. What that does is effectively to create an action in tort for breach of statutory duty. That's the basic point of it, and that brings in all the legal rules about how you assess the damages for that on a tortious measure, by method of remoteness and matters of that character.
Yes, but you were saying yesterday that even though you suffered loss or damage, there might be various reasons why it was not or no longer recoverable. That doesn't seem to be catered for by 47C. You explained the word may as catering for that sort of situation, didn't you? And maybe that's a fallback way of explaining the difference between 47C or how 47C relates to 47J.
Well, if we were to go back to 47C, one makes it actionable, and two identifies the proceedings for that purpose, and identifies the power which you get in the subsequent regulations, which gives effect, the fact it's actionable.
Yes, I see.
Sorry, that was my fourth point. I was, unless you wanted to ask me more about that, that was that particular point.
Thank you very much. That's very helpful. Thank you.
Now, Lord Panic relies essentially on the explanatory notes to support his case. Can I just refer your Lordship's briefly to Spath Holmes to support a point I made yesterday?
Yes.
About that the court should be slow to permit external aids to displace meanings which are otherwise clear and unambiguous. Could I just refer your Lordship briefly to the speech of Lord Nichols? The relevant part begins on page 397. If I can take this relatively quickly, his discussion of use of non-statutory materials begins just below letter D. I wasn't proposing to read it all out, but just to identify the relevant passage. At F, he makes the point, having said that the extraneous material assists in identifying the purpose, it's a useful tool, says this is subject to an important caveat. External aids differ significantly from internal aids. Unlike internal aids, external aids are not found within the statute in which Parliament has expressed its intentions in the words in question. The differences of constitutional importance. He then sets out passages from Fothergill and again. And then he says this, page 398. That said, courts should nevertheless approach the use of external aids with circumspection. Judges frequently turn to external aids for confirmation of views reached without their assistance. That is unobjectionable. But the constitutional implications point to a need for the courts to be slow to permit external aids to displace meanings which are otherwise clear and unambiguous and not productive of absurdity. Sometimes external aids can properly operate in this way. In other cases, the requirements of legal certainty might be undermined to an unacceptable extent if the court were to adopt as the intention to be imputed to Parliament in using the words in question the meaning suggested by the external aid. So your Lordship will see the passage which My lady will see the passage I was relying on.
Did Lord Bingham say anything? Because if I remember rightly, they all agreed with Lord Bingham, but not with Lord Nichols. I'm not saying that Lord Nichols isn't right. Anything Lord Nichols says is worth taking into account, but I think he was on his own here.
Well,
Given that Lord Bingham, everyone agreed with Lord Bingham, I just wondered if he said anything.
He didn't deal in external aids in the general terms. What he did do was he found the statute was clear and unambiguous.
Yes, thank you.
He also basically found that the ministerial statements which were sort of being relied on weren't helpful.
Yes, I see. So he didn't consider the point as a matter of principle.
Lord Nichols gave a more general approach, I think, in that respect to external aids. But in any event, I'll commend what Lord Nichols said to your lordships, my lady, as representing good sense.
Yes, I understand that. Thank you.
Lord, it's right to say that there's no external explanatory material that in terms that addresses the question whether any breach has to be sufficiently serious. Moreover, at all times, the assumption when the regulations have been drafted, whether correct or not, has been that damages were payable in respect of any breach. So it'd be scarcely surprising if the regulations reflected that fact. And as I say, the basic form has remained the same since 1991, as I think my Lord Panic accepts. Moreover, as a matter of fact, it's not the case that the regulations merely mirror the relevant directives or do no more than the minimum. And that is so even on the authority's own case. Well, it's common ground in this case that an economic operator to whom a duty is owed under Part 9 of the regulations includes a member of a consortium. Well, that's plain in the regulations from Regulation 28 sub 4. If I can just give your lordship the reference, it's volume 3, tab 33 at page 1589.
Thank you.
So accordingly, the authority can... Sorry, if your lordship wishes to see it. It's volume 3.
No, we have it. 1589. Yes.
1589.
Yep. I see it. Yep.
In these regulations, references to an economic operator, where an economic operator includes a reference to each person who is a member of the consortium. So it's page 1589, Regulation 28.4. Now, my lord, and it's on that basis the NDA makes its case.
But that's merely a sort of procedural addition, isn't it? I mean, it's merely to deal with a situation which in law may be difficult otherwise to fit into the arrangement.
Well, I was going to come to the significance of it in a second, my lord.
Because, I see. Thank you.
On that basis, the third issue arises on the NDA's case because they say we should have applied effectively for setting aside the contract award decision.
Yes, I see.
But the Court of Justice has held that a national rule which prevents one member of a consortium bringing a claim to annul a contract award decision is compatible with the Remedies Directive. In other words, if the regulations is intended to go no further, it could have excluded a member of the consortium from bringing a claim for annulment. But the Court of Justice also held that such a member cannot be precluded from bringing a claim for damages which it may suffer for an unlawful contract award. So if the regulations did no more than the minimum, the third issue couldn't arise because we couldn't have applied to annul a contract, we could only have applied for damages. Now, the relevant case...
Which you're coming to?
Yeah, I was just going to take the case. The two cases are firstly a case called Espace Trianon, which is in volume 8, tab 98, page 3580. That's that you can't apply for annulment, and that you can apply for damages is a case called Club Hotel Loutraki, which is in volume 2 at tab 20. And I can deal with both, I think, by looking simply at the Hotel Loutraki case, where Advocate General Sharpson sets out the background, and her opinion is also endorsed by the Court of Justice. So if your lordship would be good enough to go to tab 2, page 2, tab 20, which is at page 1402.
1483.
1402.
1482. Thank you. Yes.
Club
That's it, thank you.
Hotel Loutraki.
Yes.
Briefly, the facts were that the Club Hotel Loutraki was a member of an unsuccessful consortium for management of a casino, and it wanted damages on the basis that the winning tenderer should have been excluded. And what had happened was that the other members of the consortium, one goes to page 1414,
Yes.
had been excluded on the basis of various procedural grounds. If you look at paragraph 36, the action was lodged in the name of the unsuccessful tendering consortium in all 7, and the Chamber dismissed it insofar as it brought by the consortium as a whole and 4 of its members because they didn't appear and the lawyer had not been duly authorised to act. But the Club Hotel Loutraki's case wasn't struck out, so effectively the consortium wasn't a party. And
Which paragraph were you reading?
that's paragraph 36 on page 1414, just explains the background.
Oh, I see, this is the Advocate General.
From the Advocate General, yes. That's what happened in this case. Now, the legal background, if one goes on to 1429, under question 3, paragraph 95, as I understand it, by question 3, the National Court wishes to know in essence whether the Espas-Trianon case law, to the effect that remedies directives does not preclude a national rule under which only members of the tendering consortium acting together may bring an action against a decision awarding the contract, even if all the members act together but the application of one member is held inadmissible, might have to be nuanced if its application entailed depriving individual members not only of the possibility of having a decision with the contracting authority set aside, but also of the possibility of seeking compensation for individual damage suffered as a result of the irregularities of this procedure. And she says the answer to that calls for an examination of the reasoning. And if one then goes on to page 1432, where she says this about the background of 111, it's clear that as general national law may provide that where a person having had an interest in obtaining a contract as a consortium, a challenge to the decision awarding the contract must be brought by all the members of the consortium acting together, Espas-Trianon. Otherwise, it may provide that where damages are claimed on the ground that a decision was taken unlawfully, the contested decision must first be set aside. It could therefore be inferred that where national law makes such a provision in both regards, community law does not preclude the consequence that a claim for damages brought by a single member of the tendering consortium will always be inadmissible. I do not, however, take that view. The court's reasoning in Espas-Trianon is based on the premise that an unsuccessful tenderer's interest in having an award annulled lies in the opportunity of being again able to take part in the procedure as resumed after annulment of an unlawful decision, that where the tenderer is a consortium, only the consortium as such can legitimately have that interest. Individual members not having submitted a tender in their own name, often not in a position to do so, or they would not have formed a consortium that interest. That premise and the conclusions drawn from it seem entirely justified. As regards the award of the contract, the members of a consortium must all act together unless they stand that divided they fall. However, that does not necessarily hold true where a claim for damages is concerned. A decision taken in the course of an award procedure may cause specific harm to one member of the consortium but not to others. Although it's not clear from the order of a reference to what extent that may be so, the case illustrates such a situation. She did that. And then it's 117, but even where, as may be the case, the harm is spread among members of the consortium in proportion, for example, to the loss of the opportunity suffered by each of them, individual claims for damages could be dealt with separately, provided that the claim is solely for such apportionable damages, and there is no question of annulling the award, so that the consortium as a whole can be reinstated in the procedure is of no decisive importance whether the action is brought by one or some or all members of the court. And her conclusion effectively is at 121. And 124. So she was in favour of that. The court dealt with the matter 1470.
1470.
Thank you. Yep.
Your Lordship will see that the relevant question is set out in paragraph 65.
Yes.
Then if one goes on to page 1473, having set out the background, if I can just pick it up in 79, 78 and 79. With regard to the principle of effectiveness, it must be held that by the application of contested national laws, a tenderer such as the applicant in the main proceedings is deprived of any opportunity to claim before the competent court compensation for any damages is suffered by reason of a breach of European Union law by a administrative act likely to have influenced the conduct, even the outcome of public procurement procedure. Such a tenderer is thus deprived of effective judicial protection of the rights in that area of the law under which it has under the European Union law. As the Advocate General observed in points 107 to 116 for an opinion, it's important to note in that regard the present situation differs from that which gave rise to the judgment in Espèce Trianon. That case concerned an action for annulment against a contract award decision which deprived the tendering consortium as a whole of the contract. The present case concerns an application for compensation for loss allegedly caused by an unlawful decision from the administrative authority which found that such an incompatibility existed under the relevant national rules in the case of only the applicant tenderer. Having regard to the foregoing, the answer to the first question referred in case 149 is that European law, in particular the right to effective judicial protection, precludes national law such as that in issue in the main proceedings, interpreted as meaning that members of a temporary association tender in a public procurement procedure are deprived of the possibility of seeking individually compensation for loss which they suffered individually as a result of a decision adopted by an authority other than the contracting authority involved in the procedure in accordance with the applicable national rules, which is such as to influence the conduct of that procedure. So effectively the court recognised that an individual member of the consortium could sue for damages even if it couldn't seek annulment. So that shows that the regulations in this case go beyond.
I understand. Thank you.
As your Lordship knows, the Remedies Directive sets out minimum conditions, but it's simply not being copied out in the same terms in the domestic regulations.
It might be said that that was a decision after the regulations were made, might it not? Or were these regulations added after the decision?
Even if it was, it's precisely the same position as the Spiker case as well. So it would be in the same position as that.
Yes, but Spiker has a sort of ancestry which goes back beyond the regulations, doesn't it?
Well,
in terms of serious breach point, or serious, yes.
Well,
it's not a new concept.
Well, the sufficiently serious concept.
Yeah.
No, that's not new. The suggestion that the Remedies Directive only expresses that concept is new.
I see.
In Spiker.
Well, I don't know whether it's new. I mean, it appears from this interesting article to be quite a lot of different views in other countries on the subject, some of which had already chosen, it appears, serious remedies.
I was referring to this country when dealing with the regulations.
Yeah, yes, I see.
I would make the point that the regulations didn't simply copy out the Remedies Directive. Right. First, the domestic regime defines the obligations owed by the contracting authority, and it needs to be emphasised that these obligations are not merely the obligations to comply with the requirements imposed on contracting authorities by EU law, whether under the treaties or the procurement directives. They also include a failure to comply with the relevant national regulations which are set out, and that involves a breach of national law. One obvious extension are the obligations to GPA economic operators. Their rights under the GPA cannot be directly invoked, as I showed your Lordships yesterday in cases which were referred to. Their justiciable rights depend on national legislation. Furthermore, the national provisions are not necessarily identical with the procurement directives. And can I give one example which my Lord Sumption will have been previously familiar with, which is in Regulation 30 of the regulations. That's in Volume 3 of the bundle at tab 33.
Thank you.
If your Lordship would go to page 1591.
Yep.
This is dealing with the criteria for the award of a public contract. Very familiar. And paragraph 1 provides that a contracting authority shall award a public contract on the basis of the offer which is either the most economically advantageous from its point of view or offers the lowest price. If your Lordship goes on to 1592, in paragraph 10, in this regulation, offer includes a bid by one part of a contracting authority to provide services, to carry out work, or to make goods available to another part of the contracting authority when the former part is invited by the latter part to compete with the offers sought from other persons. So so what this indicates is where an authority decides to have a procurement competition and its own in-house team bids, all the bids have to be considered on the same basis when the authority decides to award the contract. And there's nothing in the Public Procurement Directive to that effect, but in my submission it's a perfectly lawful transposition about how to conduct a competition, because what it makes plain to the private sector economic operators who are participating in it, it's going to be conducted on a fair, transparent basis. That's entirely different from the position in the risk management case, which was a case about whether you had to have a competition at all to give it to your in-house operator. So, but what this does is it indicates that is a matter, and that is, one can see, if one just goes on to 1615, amongst the regulations which a contracting authority has to comply with, Regulation 39 is excluded, but not Regulation 3010.
Sorry, which page should we go to?
Page 1615.
Yes.
It's Regulation 47A. It's just, rather than to take out another bundle, it gets you to the same point.
Yeah.
If you look under the provisions of the regulations you have to comply with, 39 is taken out, but not 3010. So there's a conscious decision that that's one of the regulations which you can complain about if there's a breach. So, as I said, the national regulations aren't identical with the European regulations. It's not simply being copied out in that respect. Secondly, as I say, the domestic regime has stated that such breaches are actionable by an economic operator who suffers loss or damage. As I've said, that creates in domestic law a claim for breach of statutory duty, which is a claim in private law, as the Court of Appeal found in Matra. That's a non-discretionary private law cause of action. And what it does is it basically provides the criteria for, amongst other things, for example, it provides the criteria for how damages are to be assessed and awarded and all those matters as well. So this is not simply a copying out of the Remedies Directive. And as your Lordships have heard, Mr. Lord Pannick doesn't say there's any mal-leasing requirement to interpret the regulations in the way he contends, or that the regulations are ultra vires if construed as we contend. In terms of risk management, which my learned friend did refer to, could I refer your Lordship to what Lord Mance said in the United States and Nolan, which also explains risk management, which is in volume 6 at tab 75. If I can invite your Lordship firstly to go to page 2879, just to identify the first point of construction which Lord Mance was going to deal with. This is in paragraph 12 when dealing with the issues. He refers to the first point of construction argued by Mr. Kavanagh as that domestic legal provision should be given an interpretation conforming to that given in the first part of the Court of Justice judgment, at least as regards foreign states' iure imperii activity. That's because there was a Court of Justice judgment about the meaning of the directive. And if I can then go to page 2880, under the heading the first point of construction.
Thank you.
Taking the first point of construction, it's a cardinal principle of European law and domestic law that domestic courts should construe domestic legislation intended to give effect to a European directive so far as possible, or so far as they can do so without going against the grain of the domestic legislation consistently with the directive. That's the Mar-leasing principle. But that means avoiding, so far as possible, a construction which would not have the effect that domestic implementing legislation... I'm sorry,
which would have the effect.
I'm sorry, but that means avoiding so far as possible a construction which would have the effect that domestic implementing legislation did not fully satisfy the United Kingdom's obligations. Where the directive offers a member state a choice, there can be no imperative to construe domestic legislation as having any particular effect, so long as it lies within the scope of the permitted. Where a directive allows a member state to go further than the directive requires, there is again no imperative to achieve a conforming interpretation. It may in a particular case be possible to infer that the domestic legislature did not, by domestic formulation or reformulation, intend to go further in substance than the European requirement or minimum. It refers to risk management considered below. It's a case where the Supreme Court implied into an apparently unqualified wording of domestic regulations limitations paralleling in scope that which had been implied by the Court of Justice into the general wording of the directive, to which the regulations were giving effect, see Tekel. He concluded the two had been intended to be effectively back-to-back. Reformulation may also have been aimed at using concept or tool familiar in a domestic legal context rather than altering the substantive scope or effect of the domestic measure from that at the European level. But that is as far as it goes. And then he dealt more specifically with risk management. Lord Mance's conclusions on that, best perhaps and shortly explained in paragraph 64, which is at page 2898, where he said this about risk management. At the other end of the spectrum is a situation such as Lord Hope considered in the risk management case. That is where a directive such as the Public Procurement Directive in that case addresses an internal market competition issue by introducing procedures for the award of public works, supply and service contracts, but does not cover a situation where public authorities contract inter se, or where a local authority exercises over the other contracting party a control which is similar to that which it exercises over its own departments, and at the same time that person carries on the essential part of his activities with the controlling local authority or authorities. In that context, Lord Hope, with whose judgment the other three other members of the court agreed, considered it would be not be a permitted use of the power conferred by Section 2.2 to apply to the public procurement rules to relationships such as those in 2 and 3 that fell outside the regime provided for by the directive. In agreement with Lord Hope, I consider that where a directive is based on an internal market competence and as a result limited in impact to internal market situations, its domestic extension to situations outside the internal market cannot be regarded as being within either Section 2.2a or b of the 1972 Act. That's so whether it's limited by implication or expressly. In other words, the regulations had to be construed to be intra-varies rather than outra-varies, which is the explanation, in my respectful submission, of the risk management decision. My Lord, before moving to issue 3, can I say a word about a reference? If the court is with the respondent on issue 2, then there's no need for a reference because we won't, as a matter of domestic law, have to satisfy the sufficiently serious test. But if the court was to be against the respondent on issue 1 and 2 as a consequence of the Spiker decision, then I would invite the court to make a reference. Your Lordship knows from the Kerbler decision, I'll just give your Lordship the reference, it's paragraph 118 at page 3575. It's tab 8, volume 8, tab 98. There's an obligation to refer unless the resolution of the issue is clear from the settled case law of the court or leaves no room for any reasonable doubt.
Sorry, what was the Kerbler reference?
It's volume 8, tab 98. It's page 3575.
It's all right.
I've given your Lordship the wrong reference.
Right.
I may have given your Lordship the wrong reference. Sorry. No,
It's 97.
97. I'm sorry, my Lord.
Yeah.
If you go to 3575, this was a case where a court actually withdrew, what went wrong was the court withdrew its reference. 118. What the Court of Justice said, that court was not entitled to take the view that the resolution of the point of law issue was clear from the settled case law of the court or left no room for any reasonable doubt. It was therefore obliged under the third paragraph to maintain its request for a preliminary ruling. So the test is whether the resolution of the point of law at issue is clear from the settled case law of the court or leaves no room for any reasonable doubt. My Lord, in my respectful submission, the Spiker case doesn't meet that test. It is a single case. It's inconsistent in my submission if it's to be interpreted as your lordship, as my learned friend wishes to interpret it, with other cases such as Strayberg and the Portugal case. It didn't address the position with respect to the GPA, and in my respectful submission, it's a matter which should be referred, if it's necessary, for that issue to be determined for the purpose of disposing of this appeal. May I now turn to the third agreed issue? This is about whether the mitigation aspects of the case. My Lords, Lord Panic approached this issue as if the only question concerns starting the claim before the contract is concluded. But that by no means indicates the full extent of the claims which the authority is making in this case. Its case is that the claimant must not unreasonably fail to do anything which would stop the contract being wrongfully awarded to another person. That's the basic underlying point. That includes not only starting the procedure, but it would also involve, given the way the regulations are set out, opposing any application by a contracting authority to lift the restriction on concluding the contract and offer an undertaking in damages to support that approach. So,
Well, it would potentially involve that. I mean, it's a question, what was said against you, that proposition, is it's far too wide. It would involve doing something provided that it was
not
either reasonable to do it or not unreasonable not to do it.
yeah, well, you'll be required to do it unless it was reasonable for you not to do it, effectively.
Not unreasonable for you.
Well, that is the problem of negatives, I'm afraid.
Yeah,
negatives. Now, that obviously, I'll make the speech in law a moment, but it does produce some very odd practical results, because if you think that damages are an adequate remedy for you, and you go to if there's an application to set aside the restraint, which its common ground is determined on American cyanamide principles, what you'll be, if you would say to the court that you thought the damages were an adequate remedy, then it's in all likelihood, as Mr. Edward Stewart pointed out, that the restraint will be lifted. It's very odd that you should in some way be required to contend that damages are not an adequate remedy, if that's what you think. Or
but the problem here is, how far do you go? Because, the trouble is we're looking at this in the abstract. Are you saying there are no circumstances in which at the damages stage you should be allowed to investigate whether you acted wholly unreasonably and not seeking to stop the thing at an earlier stage?
yes, my lord.
If the remedies, you say no, you've got to say no.
What about the contract award? It may be that you'll be out of time to do it. So, for example, if what happened at an earlier stage that there was a breach, and you don't do anything, you may well be out of time for challenging that later when, if the contract award goes against you. But one of the points I've been making is about the structure of the regulations, about how this works.
What are you saying? If you are, you're saying that's a case where you could investigate it or you couldn't?
Well, if you were out of time, then the court wouldn't be investigating it at all. You'll just be out of time for doing it.
But you are saying that there are no circumstances in which at the damages stage you can investigate whether you failed to take steps which were reasonably open to you?
Failed to start the proceedings.
You failed to take steps which were reasonably open to you.
If they are. Can I address the legal issues? And I'll come to the point you'd already be asking in practice.
Can I just take up that point? The normal function of reasonableness in this kind of legal problem is that if somebody has behaved unreasonably in response to some problem, one infers that the consequences, e.g. by way of damages, were not actually the cause of the problem, the unreasonableness being an intervening cause. Now, on any view, I think even on your own submissions, any damages recoverable have got to result from the breach. There must be circumstances in which the unreasonable character of the claimant's own behaviour simply mean that any damages that you've suffered are simply his own fault and not the consequences of the breach. Would you accept that much?
With that much, but one needs to see where mitigation kicks in, if I can put it that
Well,
way.
it's not just a question of mitigation. Well, mitigation in English law is analysed as an aspect of causation. But any issue which involves examining the reasonableness of the victim of a breach's response is essentially going to be a question of causation. One would think in any system.
Can I show you, Lordship, how the English law has answered that?
I mean, it may be that this question, I mean, obviously if you take an absolute line, then it's a crisp question of law. But it may be that this question is just not capable of being answered except at such a stratospheric level of generality as to be of really remarkably little use to the parties.
Well, can I develop my submission to your Lordship? We'll see where they go. The first question which needs to be addressed is whether the law to be applied is European law or national law. My own friend seeks to invoke European law in some way to govern the matter. Lord, in my respectful submission, it's quite clear that the Court of Justice regards the question whether the claimant should have mitigated its loss as being relevant to the extent of the reparation which may be due, and that it's a matter for national law to set the rules for that matter. I mean, that in my submission is clear from both Brasserie de Pêcheur and the Danske Slagtera case. If I can just take your Lordship back to those. Firstly, Brasserie de Pêcheur, which is Volume 1, Tab 13. Your Lordships will go to 1146. It's important to see where the paragraphs which my learned friend rely on appear in this judgment. They're dealing with the question about the actual extent of the reparations one can see from the cross-heading. And the question is whether national courts ask the court to identify the criteria for the extent of reparation due to, by the member state responsible for the breach. It talks about commensurate. In the absence of relevant community provisions, it is for the domestic legal system of each member state to set the criteria for determining the extent of reparation. However, those criteria must not be less favourable than those applying to similar claims based on domestic law and must not be such as in practice to make it impossible or excessively difficult to obtain reparation. In particular, in order to determine the loss or damage for which the reparation may be granted, the National Court may inquire whether the injured person showed reasonable diligence and so forth. So what is being said there is that it's for the domestic legal system, and it's permissible for the domestic legal system to inquire about mitigation, in particular whether he availed himself for the legal remedies available to him. And that it's a matter for the national legal system. It is also picked up when one looks at the conclusion in paragraph 90, where it says the reply to the national courts must be that reparation by member states for loss or damage which they've caused to individuals as a result of breaches of community law must be commensurate with the loss or damage sustained. In the absence of relevant community provisions, it is for the domestic legal system of each member state to set the criteria for determining the extent of reparation. Then it deals with limitations on that. So the court's approach is that rules as to the extent of reparation, which involve questions of mitigation, are matters for the national legal order to set out those rules. And that's similarly the approach in Danske Slagtera, which is in volume 2.
How does this fit with the seriousness test, which we see elsewhere used in relation to state liability? Had that not been developed by then, or by the time of Brasserie du Pêcheur?
Well,
Or is it referred to?
yes, so if your Lordship goes back to 1142.
Sorry, 1142, yes.
Your Lordship, this is the...
Yes, I see. So when exactly that? So when it says in paragraph 90, in the absence of relevant community provisions, it really means assuming that the provisions of paragraph 56 are satisfied, does it?
Yes, I mean,
Yes, it means assuming there is liability, how is it quantified?
Yes,
Basically, isn't it? Yes.
Exactly. So it's looking at mitigation under that aspect of it, and saying that the rules about that are a matter for the national legal order.
Yeah.
Subject to equivalence and effectiveness, of course. Similarly, in Danske Slagtera, which is volume 2, tab 17. Lordship will go to page 1292. This is question 5 in Dansk Kriterium. The court was asking whether community law precludes a rule such as that laid down in the legislation, which provides an individual cannot obtain reparation for loss or damage which is willfully or negligently failed to avert by using a legal remedy. And the referring court elaborates on its question by asking whether such national rule be contrary to community law insofar as it applies subject to the proviso that recourse to the remedy must be reasonable and so forth. Then paragraph 59. As has been recalled, when answering the previous 2 questions, it is for member states, in the absence of community legislation, to lay down the detailed procedural rules for legal proceedings intended to safeguard the rights which individuals derive from community law insofar as those rules observe the principle of equivalence. As regards utilisation of legal remedies, the court held in Brexit Pashur, in relation to liability of a member state for breach of community law, that the national court may inquire whether the injured person showed reasonable diligence in order to avoid the loss or damage or limit its extent, and whether in particular availed himself of the legal remedies. It then deals with the point at 62 about the requirement for reasonableness, and the conclusion in paragraph 64 is it cannot be concluded that community law does not preclude the application of national rules such as that laid down, provided the utilisation of the legal remedy in question can reasonably be required for the injured parties. So, again, the approach is it's a matter for national law subject to principles of equivalence and effectiveness. Effectiveness must mean that it's reasonable. That's the if you are going to impose such a requirement. It's not a matter for EU law as such. My Lord, Lord Panic sought to extract some rule as mitigation from the Remedies Directive itself as well. He stated that it's concerned in particular to provide remedies when errors can still be corrected, and he referred to the Alcatel decision as illustrating that point. Lord, can I make the following points in response to that? Firstly, the Remedies Directive imposes no obligation on an economic operator to seek one remedy in preference to another.
Right.
Secondly, the Remedies Directive gave member states the option to provide that an economic operator had to seek the setting aside of a decision before seeking damages. The United Kingdom has not taken that option up.
Right.
Thirdly, the standstill provisions are in fact inconsistent with his argument. Alcatel merely established that the opportunity to challenge the contract award decision had to be provided. It did not suggest that the economic operator had to take advantage of it. Further, when the standstill period was incorporated into the directive, member states were given a discretion to set a time limit for bringing any claim in respect of the contract award decision that was longer than the minimum standstill period, and that the United Kingdom has done. It has not said, for example, that the standstill period is longer than the minimum and a claim must be brought within that extended period unless there's some reason not to do so. That means that it was expressly envisaged that national law might allow a claim to be brought after the contract had been concluded, when national law provides that only damages may be claimed, even if it could have been brought within the standstill period. There's no obligation to do so. Fourthly, in Spiker, the court held that in the absence of any EU provision, whether an economic operator has suffered any damage is to be determined and estimated in accordance with the rules of the relevant national legal system, provided principles of equivalence and effectiveness were observed, and that's inconsistent with Lord Panic's submissions. Fifthly, as I say, what the NDA says about the position on the basis of EU law alone, if the contracting authority applies, if the contracting authority applies to set aside the automatic suspension if it's invoked, is not clear. As I've made the point, it's common ground that the regulations requires the court to approach that task on the basis of American cyanamide principles. And as I made the point, Lord Sumption, if damages are an adequate remedy for the claimant, the restraint on entering into the contract is unlikely to be continued. And it's not suggested that that is incompatible with EU law. Why then should a claimant who thinks that damages would be an adequate remedy oppose the application, much less be obliged to offer an undertaking in damages? And EU law has nothing in my submission to say on that matter at all in the Remedies Directive. As I say, in my submission, what an economic operator is required to do to mitigate any loss is a matter for national law to determine. Lord, in my respectful submission, the NDA's case is untenable in principle. There is no obligation to take legal action to prevent a person wrongfully doing that which will cause the claimant loss, in this case, concluding the relevant contract.
The trouble is that the case law we were taken to, and I know that there's a balancing case on the will issue, suggests that, I suppose one might say that it's not a case of it's never right to expect somebody to take proceedings, as it were, in mitigation, but there are cases when it can be. Unless those cases are wrong, can we say as a matter of principle, whatever the circumstances, it can never be right?
Well, those cases, exceptional though they are, I mean, I'll come to them, are cases for taking legal action against a third party, not against the wrongdoer. And there is a significant difference in the position between them. Can I deal with the 2 points principle first, and
yes,
then I'll deal with the cases? Firstly, in my submission, any loss that results for what a defendant is left free and chooses to do remains attributable to the defendant's own action. And that principle underlies two features of the approach to the grant of interim relief in our law. The first feature is that if damages will be an adequate remedy, there are no grounds for interference with the defendant's freedom of action by the grant of an injunction. That's the point which Lord Hoffman made in the National Commercial Bank case. And if I briefly show your Lordship that, it's in volume 1 at tab 10.
Yes.
At page 959.
Yes.
This is a very well-known case, but can I just draw attention to the point you made just below letter B when referring to American cyanamide?
Page 959.
959, my Lord. It's just below letter B, if your Lordship sees the reference to American cyanamide. Yes. As the House of Lords pointed out in American cyanamide, that means that if damages will be an adequate remedy for the plaintiff, there are no grounds for interference with the defendant's freedom of action by the grant of an injunction. Now, that necessarily means that the defendant remains liable in damages for any loss which results from whatever he may freely then choose to do. The second feature of the law on American cyanamide is that the claimant may only be required to offer an undertaking of damages to a defendant as a condition of the grant of an injunction to him. The refusal to offer one merely results in the refusal of the injunction sought. It has never resulted in the loss of the right to claim damages if the defendant goes ahead. And the whole principle underlying it is that what the defendant is left free to do remains attributable to the defendant himself. They've chosen freely to go on and do it.
The failure to go for an interlocutory injunction may penalise your prospects or reduce your prospects of getting a final injunction, but they don't impinge on your right to damages. Yes, I see. And
the underlying principle for that is that what the defendant is left free and chooses to do remains attributable to his own action.
I see that.
Lord, secondly, as a matter of principle, a claimant is under no obligation to seek the remedy that will best suit the defendant or which reduces its liability. A claimant is free to elect whatever remedy against a wrongdoer that may be available, which is most advantageous to it. Now, Lord, can I refer your Lordship on the entitlement to choose, firstly, to the Deutsche Morgan case, which is in volume 5, at tab 63.
Interesting. That's page 2501.
2501.
Well, the classic example of this is that you can rescind a contract in circumstances where it will impose a very much larger liability financially on the other contracting party than if you simply sought damages.
You can do whatever is to your best advantage, as you consider it. Lord, the issue was whether, in this case, whether the claim was time barred, and that would depend on which way the claimant put his case in restitution.
Yes, in a sense, you're saying it's turning the right to elect on its head and turning it into an obligation to elect.
Yeah, well, they're turning it an obligation to elect in favour of the defendant, whereas you're entitled to elect to do whatever you think. Well, can I just refer your Lordship to what Lord Hope says?
Yes, of course.
2522.
Paragraph.
Sorry, I'm just getting the reference. I think it's paragraph 50. 2522. Yes, at page 2522.
Thank you.
Paragraph 51.
Yes.
There is no obvious way of deciding which of these two approaches must be adopted if only one can be allowed. The question, however, is whether a claimant is under an obligation to select the remedy that will best suit his opponent. In his note on this case, restitution in respect to mistakenly paid tax, Professor Andrew Burrows said the starting point for a principled analysis is, in general terms, now that this concurrent liability is accepted, a claimant ought to be free to choose between causes of action. It would be odd from one cause of action offering advantage to a claimant to be knocked out by a wider cause of action which does not offer that advantage. It would indeed be odd. I can think of no principle that justifies such a strange result. The answer to this point is to be found in the observation by Lord Goff in a case where the question was whether a contract legislated exclusively for the parties with the result that a parallel duty of care was excluded by it. He said there's no sound basis for a rule which automatically restricts the claimant to either a tortious or contractual remedy, and there could be no objection to his taking advantage of the remedy which was most advantageous to him. We're in a different field, but I think the reasoning is just as compelling in this context. See his reference to the Climate-Benson case. It's the usual preference of English law to allow either of two alternative remedies to be available, leaving any possible conflict to be resolved by election at a late stage. That is, you have to make your election.
At some point you've got to elect, yeah.
But you're entitled to choose which of the remedies which are available to you, which you think best suits your advantage. Lord, that was the whole basis of a subsequent case about the test litigate claimants. I wasn't going to take your Lordship to it, but it's volume 669. It proceeds on that basis.
Thank you.
Now, my Lord, the same is true in equity. That's to say, a principal is entitled to elect the remedy which is most advantageous to him. We've put Snell's equity in the bundle. It's at volume 9, tab 111.
Thank you.
And page 3818.
Yep.
Where it says the principle...
Election between inconsistent remedies. Yes.
I'm sorry, this is Snell's equity,
Yeah.
32nd edition.
And it's really 7052, the first
Yes,
sentence.
exactly,
Really
exactly,
is says it all.
Exactly.
Yeah.
So if the claimant considers that damages will be an adequate remedy for it, it's perfectly entitled to elect a claim on that basis.
You understand?
And I say common law and equity have never required an innocent party to elect to pursue other rights and remedies against the wrongdoer or face the loss of a right to claim for damages. And that's because you've got an unfettered right to choose. Well, that's illustrated in the Solholt case in volume 4 at tab 46, which makes it plain that the obligation to mitigate may arise after you've made the election, but doesn't affect the election itself. If your Lordship will go to tab 46.
Sorry, where have we gone now?
Volume 4, tab 46, my Lord. This was a case about compensation for effectively late delivery. the compensation clause was clause 14, and it was conceded that the claimant was entitled to cancel the contract. If one goes to page 1927, just to see what the significance was, it says this is in dealing with the commercial court judgment by Lord Justice Staunton, by Mr. Justice Staunton's then was, just to see the facts. Number 5, damages with the difference between the contract and the market price. Since the market price at August the 31st, that was the date for delivery, was $5.5 million. The buyers are entitled to $500,000 by way of compensation. However, Lord Justice Staunton said, since the buyers would have accepted an offer by the buyers to purchase the vessel at the original price, subject to any claim they might have had for the delay, the buyers were on the facts were entitled to failed to mitigate their loss, only to $500,000. And the Court of Appeal held too. The buyers had an unfettered right to affirm or cancel the contract to sell. They decided to cancel it. In consequence, they suffered a loss of $500,000. Loss was directly attributable to the sales breach, but could have been avoidable by some reasonable further action. And that's the crucial bit, because mitigation applies to the further action. So if one goes to the judgment, at page 1928, where my Lord Sumption was acting for one of the parties, if we can just see how he put his case. He said, this last complete paragraph on 1928 in the right-hand column, Mr. Sumption's appeared for the buyers. His broad point is this: the sellers were in breach of the contract in failing to deliver the vessel by the due date. If they had delivered by that date, his clients would have acquired a vessel worth $5.5 million at a cost of $5 million. It's trite law that in deciding whether or not to exercise a right to cancel the contract in such circumstances, the buyer need have no regard to the fact that in the absence of cancellation, he would suffer no loss. And that's the point which the court in fact endorses. If he cancels, the loss will be attributable to the seller's breach of contract and not to the cancellation. How comes it then that having cancelled the contract and suffered a loss, the buyers are expected in effect to reverse the decision to cancel the contract by entering into a new contract at the same price as the old, and to do so purely because that will eliminate their loss? So that was my Lord's submission. And if one then goes to page 1929, after the quotation from the British Westinghouse case, what the Court of Appeal said this: so we've already accepted as being trite law the buyers had an unfettered right in the circumstance of this case to affirm the original contract to sell or to cancel it. No question of mitigation arose at that stage. They decided to cancel and in consequence suffered a loss. As a matter of causation, this loss, unless avoidable by some reasonable further action, was directly attributable to the seller's breach of contract. It was the further action which they should have taken, which was to accept the alternative offer to mitigate their loss, which caused them to be reduced. But the principle is that you're entitled to elect whatever remedy you like. Once you've elected, the obligation to mitigate may arise. So it's the further action thereafter. That, in my respectful submission, is the principle.
So you say that, as it were, Mr. Lord Panic requires them to, as it were, to exercise mitigation at too early a stage, before they. It's an election point, not a mitigation point.
Yes. Well, we're entitled to claim damages.
Yeah,
that's what we want. Lord, so far as the other cases which are concerned, there are exceptional cases in which a client of a professional advisor may be expected to take proceedings against a third party.
I understand that point.
To mitigate the consequences.
Yeah, I entirely see the force of that.
Yeah. But Lord, I should say that they are exceptional.
Yeah, well, that's right.
Unless Your Lordship wanted...
I would have thought they must be quite common. I mean, if your builder leaves the keys of your front door and someone comes and squats in your house, it's obvious that you can't claim loss of the house against the builder. You've got to evict the invaders. Yes.
I agree with the Lordship on that particular point.
Many circumstances where you actually have to take legal proceedings against third parties.
The question, it seems to me, the question is whether the proceedings are clear and obvious, like getting squatters out, or whether they are complicated, as in Pilkington and Wood.
Exactly. The Walker and...
I mean, all the cases in which this kind of mitigation has been held appropriate are cases where the defendant's breach of duty has caused some transaction to be defective, and there is an alternative way of making it undefective, so which it may occasionally be reasonable for you to have adopted. You basically have always had your right, in Lord Mance's example, to your house, and you haven't lost it. If it's still available to you, by resort to the courts. And that suggests that there are some circumstances in which you simply can't claim that the loss has flowed from the breach if your choice of ways of acting is unreasonable to a sufficient degree.
Well, Lord, can I separate what your Lordship is putting me into 2 points? Firstly, the question of principle about whether, this is why it is significant that they are against third parties, these cases, is that effectively there's no obligation effectively to stop someone doing something which will be wrong and cause you loss. There's no obligation in that sense to go and get an interim injunction or anything of that character. Otherwise, in every case in which there's a tort or a breach of contract, if you had the opportunity to go and get an injunction before the tort or breach of contract actually occurred, you'll be under an obligation to go and do it. But that's never been the case. It will be a complete sea change in the law about claims for damages for breach of contract and tort.
Is that right? If you see that your neighbour's tree is about to fall on your house, don't you? Can you just say, "Well, I wait and see whether it falls"? No, mightn't you not be under some obligation to take steps, even legal steps, to get him cut it down?
Well, you may be entitled to do that. So I don't want to get into the law about undergrowing trees, but causing subsidence. The point I make is that you're entitled to choose what legal remedy you choose to do that and elect whichever it is. You're not under an obligation to go and take legal action to prevent the wrongdoer doing what he's proposing to do. If he goes ahead and does it, the consequence of his action remains attributable to what he freely does. Sorry, I was trying to answer my Lord Sumption's question. There are principles which are concerned with when mitigation comes into play, and what Lord Donaldson was saying in the Solhold is they come into play once you've elected which remedy you want to pursue.
I see that.
That's that. The case is Western Trust is actually quite a good illustration of what Lord Sumption is putting to me in one sense, which is there was a negligent advice about security. What you were expected to do was to enforce the security anyway, because in that case it would have covered your any loss given the value at the time.
But you're enforcing it against a third party, not against...
Yes, against
that's
a third
your
party.
point.
That's perfectly reasonable to do, because that's what you'll do in any event. The other case, Walker and Medlicott, there are in fact some good policy reasons behind the judgment. My Lord was referred to part of Sir Christopher Slade's judgment, but one of the points he made was about adventitious benefits which could result in those circumstances, because if you don't get rectification for a moment, what would happen is other people would enjoy the benefit of the will which...
well, yes, that's a dangerous line of argument for you, isn't it? Because in this case, if the wrong person gets the contract, because you don't stop the contract going ahead, there's an adventitious benefit, it could be said.
Well, the policy point there, which one can find from the judgment of Lord Justice Simon Brown, was that because one was dealing with a will where the beneficiaries might cooperate to that purpose, there might be policy considerations here. There's obviously going to be any cooperation between ourselves and the winning bidder. That's not going to happen. But at any rate, your Lordship has my basic points about those cases.
Yeah.
There are cases which say that the general rule is you don't have to sue, but your Lordship would be familiar with that.
Well, yes, and there's the later case which distinguishes Walker and Medlicott, which is the next one in the bundle.
Yeah, it's Horsfall and Haywards, which is that. The other case is more recent is Peters and East Midlands Strategic Health Authority, where the judgment was given by my Lord Dyson sitting in the Court of Appeal, where he made the point that you're free to elect what you wish to do. Can I just tell you where that is, if your Lordship is interested in it? It's sorry, I'm volume 5 at tab 65. I'll show you.
Page 2578. Thank you very much. Yep. Okay, very well.
And can I just tell your Lordship where the relevant paragraphs are if you
Yes, of
want
course.
to read
Thank
it? If you go to it's paragraphs 33.
Thank you.
I think sorry, I'm just get this 25.
Yep.
Of following 2594 and following. Sorry, I'm just.
Yes.
Yeah, 2594. In particular, his analysis of the Ouzel case on page 2595.
Thank you.
And following, and going down effectively to paragraph 41. But your Lordship will see that.
Percy.
Lord, my next point, if I may, on this is that the NDA's case is inconsistent with the regulations and the principles of legal certainty and effectiveness required in national law. Lord, effectively, what the NDA claims is that any claim for damages must be issued and the contracting authority notified of it before the contracting authority enters into the contract, unless it's unreasonable for the operator to do not to do so, and in any event within the 30-day period which the regulations allow. And in my respectful submission, if that it effectively imposes a time limit on issuing a claim for damages, which is incompatible with the regulations and European law. It's incompatible with the regulations because the regulations give you 30 days to issue. It says you must start the claim within 30 days. So that's your obligation. Lord, they also don't provide that any claim with respect to a contract award decision must be served before the end of any extended standstill period, unless it couldn't have been issued and served earlier, to secure an automatic extension. It simply doesn't provide for that. Lord, moreover, the requirement would be even more uncertain than the requirement which was considered by the Court of Justice in the Uniplex case and the Commission on Ireland case. Your Lordship recall, I'll take Your Lordship in a minute just so Your Lordship to know what the facts were. Uniplex was dealing with the requirement in domestic law to bring a claim promptly and in any event within 3 months. Mm-hmm. The Commission on Ireland was to bring a claim as soon as possible and in any event within the period. And what the Court of Justice held was that because that gave a discretion which a claimant couldn't be certain about how it was going to be applied, that was incompatible with the principles of legal certainty. Well, can I show you that? Firstly, at Uniplex, which is in volume 2 at tab 19.
Yep.
And if I can invite Your Lordship to go to page 1397.
Thank you.
This is dealing with the first part of the second question, if Your Lordship has got that. Paragraph 37. By the first part of the second question,
Yep.
National Court asks in essence whether the directive is to be interpreted as precluding a provision, such as Regulation 47B, which requires proceedings to be brought promptly. So that was what they were focusing on. And paragraph 39, the objective of rapidity must be achieved in national law in compliance with the requirements of legal certainty. To that end, member states have an obligation to establish a system of limitation periods that's sufficiently precise, clear and foreseeable to enable individuals to ascertain their rights and, I would note, obligations. Then deals with effectiveness. And it then says 41, a national provision such as Regulation 47.7b, under which proceedings must not be brought unless the proceedings are brought promptly, in any event within 3 months, gives rise to uncertainty. The possibility cannot be ruled out that such a provision empowers the national courts to dismiss an action as being out of time, even before the expiry of the 3-month period, if the courts take the view that the application is not made promptly within the terms of that provision. As the Advocate General observed in point 69 of her opinion, a limitation period, the duration of which is placed at the discretion of the competent court, is not predictable in its effects. Consequently, a national provision providing for such a period does not ensure effective transposition of Directive 89/665. It follows that the answer to the first part of the second question precludes a national provision such as that at issue in the main proceedings, which allows a national court to dismiss as being out of time proceedings seeking to have an infringement of the public procurement rules established, or to obtain damages for an infringement of those rules on the basis of the criterion appraised in a discretionary manner that the proceedings must be brought promptly. Now, Lord, as I say, the Commission in Ireland, which is a case which was heard roughly at the same time, was decided on the same basis, where the criterion was as soon as possible, and was said not to meet the requirements of legal certainty, because that, again, failed to be ascertained in what the court regarded as a discretionary matter. But there, all that the court would be considering was whether you had done something as soon as possible or promptly, which is a fairly narrow judgment for the court to make. If the court is going to have to make a judgment about whether or not a claimant acted unreasonably in failing to invoke the procedures, that will involve a far wider discretionary judgment than simply asking whether it's brought promptly or not. And that means that you wouldn't know when you had to bring your case. And therefore it wouldn't satisfy the requirement, in my respectful submission, of certainty.
Understand.
Moreover, in my submission, any obligation which required an economic operator to offer an undertaking in damages, if it wished to pursue a claim in damages, even if it was provided for in regulations, which in my submission would have to do to meet the requirement for certainty, would unlawfully tend to undermine the effectiveness of the remedies regime. It would be liable to discourage a substantial proportion of potential litigants from lodging arguable claims when they cannot be reasonably certain the claim will be successful. And in that respect, I refer you to the court, a case called Star Storage, which is in volume 9 at tab 105.
Yes.
Lord, can I begin with Advocate General Sharpson's opinion?
Yes.
Your Lordship would see at page 3692 that what this case concerned was the requirement for a claimant to lodge what was called a good conduct guarantee in order to invoke the review procedures.
Yep, sorry. Yep.
Well, it's page 3692.
Thank you. Yep.
Effectively, what was an issue was what was called a good conduct guarantee, and it was effectively an amount equivalent to a percentage of the contract value. That was what it was. Now, if you go to paragraph 33, for judgment.
Yep. That's page 3698. Yep.
3698. She addressed firstly the question of what was the relevant test for the question of effectiveness in this area. She said, first, can that principle be limited to verifying that a national procedural requirement such as that in issue in the main proceedings renders practically impossible or excessively difficult the exercise of the right to review procedures set out in Article 1, or is it broader in that it requires any national rule which undermines those provisions to be set aside? And she adopted the undermining part. If one looks at paragraph 35, she says this, in my view, what matters ultimately is to ensure the rights which EU law confers on individuals receive more rather than less protection. Article 1 of the Remedies Directive and Article 1 of the Utilities Remedies Directive give specific expression to the right to an effective remedy. It's therefore not possible to limit the analysis of the principle of effectiveness to whether a procedural requirement such as that an issue in the main proceedings is liable to render practically impossible or excessively difficult the exercise of that right. Rather, in that specific context, the effectiveness test must surely involve examining whether a requirement is liable to undermine that right to effective review procedures. And that's the test which the court eventually adopts as well. Maud, if one can then go on to 3701, where she considered the original regime. What she said in paragraph 49 was this. Under the original regime, the applicant automatically loses the good conduct guarantee where his challenge is rejected or where he withdraws it. That is also true where there are no elements present suggesting an abuse of the review procedure, because the challenge is manifestly or founded or was lodged with the sole purpose of delaying the contract award procedures. For reasons similar to those I set out above, the original regime thus significantly impedes access to review procedures against decisions of contracting authorities for persons who, even if their challenge ultimately fails, have arguable claims. It's therefore liable to discourage a substantial proportion of potential litigants from lodging a challenge if they cannot reasonably be certain that it will be successful. Examples of such circumstances would, I suggest, include where there is no settled case law on the point at issue, or the challenge seeks to call in question an assessment of contracting authority of which the latter enjoys a wide margin of appreciation. It seems it would have been possible to avoid that adverse effect without undermining the objective of discouraging frivolous challenges. Where a challenge was rejected or withdrawn, the court might, for example, have been given latitude to ascertain whether the challenge was frivolous or not, taking into account all relevant circumstances. I therefore agree with Star Storage and the Commission that the original regime involved a disproportionate limitation on the right to an effective remedy protected under Article 47 of the Charter, and therefore undermines the effectiveness of Article 1 of the Remedies Directive. Now, what happened in the court was, if one just goes ahead, was that was that the provisions for forfeiture were declared under the original regime were declared unconstitutional by the court. So if one goes to page 3720, sorry, 3718. 3718, paragraph 36, your lordships will see in paragraph 36 is basically the two referring courts have indicated they can no longer apply the provisions which the remaining court confirmed at the hearing. That's about the original regime. So the court didn't consider the original regime, but they did adopt the point about the charter tests. If one goes to 3720, where they say, in particular, care must be taken to ensure the effectiveness of the remedies directives are not undermined. So your lordship, see, they adopted Advocate General Sharpson's test. In this case, however, because at this stage you've got an automatic refund of your guarantee, they said that that wasn't disproportionate. So they didn't have to consider the position, which was the original one, where you might not get it back if you lost. But my lord, what I do suggest is that the Advocate General's opinion does indicate that were you to be required to give an undertaking damages, it was thought reasonable for you to give an undertaking damages. That may well deter people from having arguable claims and therefore infringe the principle of effectiveness in that respect. Lord, there are two cases which...
I think another 5 minutes.
Another 5 minutes. Very short. I was only going to deal with the two cases.
I just wanted to warn you so that you were...
my time.
Fine. We won't clock watch to the extent of 1 minute. But,
the final two cases my learned friend referred to were Mass Energy and Gavin and Haringey. Well, both of those cases were judicial review, where there's a discretion, as your lordships will know, under the Senior Courts Act, to refuse relief if there's undue delay, and both of them fell into that category.
Yes.
Lord, so far as Gavin is concerned, that wasn't looking at whether the claimant had should have sought interim relief. It was looking more at the question of whether the developer had acted reasonably going ahead with the development, given that there was no application for interim relief. Lord, as I say, those were the only additional points I was going to make, unless there's anything further which your lordships wish to ask.
Just me on one thing. We've got this article from Mr. Troyman, or Dr. Troyman's, whatever he's called, which is from 2011, which is shortly after Spiker. We've got an article by Collins, I think, Anthony Collins, from 2014. That's 9115. We seem to have got a passage from the second edition of Arrowsmith at 1110, but not the similar passage from the current edition.
No, well, that's because Professor Arrowsmith has adopted a perfectly proper approach to revising her book. Instead of having one book, she's now having two books. And the remedies part is in the second book, which hasn't yet.
Good, well, that answers my question. Thank you. So the sort of latest we've got, really, is the Collins article, and apparently lots of articles in other languages which were not being...
Whilst you're referring to the Collins article, could I just make one point on it whilst you're there? It's page... This Collins article, which your lordship's referred to, it's on page 3838, because although he talks about Spiker, he does refer to Stat Gratz.
Yes.
And what he says about StatGrats in 3838 is that it contains further gloss on the limits of member states' discretion, since it held the availability of damages could not be subject to restrictions which did not apply to other remedies envisaged by Article 2.1. Well, there's no restriction about sufficiently serious on the other remedies available by 2.1. So, I fear his piece merely shows that there may be a tension between the two cases on that route. Lord, as I said, unless there was anything further to assist your lordships with, those have been my submissions.
I apologise for drawing your attention to the time. You obviously had it well under control. Thank you, Mr. Howell. Mr. Hunter. Thank you very much. Lord Panny.
Thank you very much, my lords, my lady. Lord, the first question, the factor tame issue, we say is determined by Speicher. My friend began by relying on the terms of the Remedies Directive, to which the answer is that the Court of Justice itself in Speicher, paragraph 86, said in terms that Article 2.1c contains no detailed statement as to conditions, etc., etc. I won't take the court back to it unless the court wants to see it again. And similarly, paragraph 87. My friend's submissions on Speicher, with great respect, cannot explain the references to the concept of sufficiently serious in paragraphs 87 and 92. Nor can he sustain, with respect, his suggestion that the court in Speicher was somehow distinguishing state liability from liability under Article 2.1c. On the contrary, as I think my lords, Lord Mance and Carnworth pointed out to my friend in argument, the Court of Justice is treating liability under the directive as a form of state liability. And that's not surprising, because the Remedies Directive, like the Substantive Directive, is concerned with entities performing state functions. So my friend's case has to depend on StatGrats. StatGrats was, it's volume 2, tab 21, your court has seen it now, is concerned with legislation which made the state liable when, unless it showed it was not culpable. So the case was simply not concerned with the factor tame criteria. It was not asking or answering the question whether those criteria apply in the context of the Remedies Directive. And the court itself, it's not accurate with respect to say that one has two authorities, StatGrats and Speicher. One also has Brasserie du Pêcheur, which at paragraph 75 to 80 explains, the Grand Chamber explained, there is a distinction between the second factor tame criterion of sufficiently serious and the question of whether damages can be made dependent on fault. And for that reason, the references in StatGrats to questions of fault cannot, in principle, in any way qualify what is said in the later decision of the court in Speicher, that the factor tame criteria apply. As the court has seen, StatGrats is referred to in Speicher, so the court was well aware of it, and there's no suggestion of any conflict. And my Lord, Lord Mance made the point that the Advocate General's opinion was dispensed with in StatGrats. I say unsurprisingly, because it's plain additional criteria cannot be added to confine damages claims, additional, that is, to the factor tame criteria. My Lord, Lord Mance asked about academic authority. I say that Professor Trumer's view on Strabag, on StatGrats, is simply incorrect, with the greatest of respect. It is unsustainable by reference to the judgments of the Court of Justice. I do rely, and I'm grateful my Lord Carnworth referred to the article by Judge Collins. We referred to this in our written case, but I did not take the court to it in opening. When I take the court to volume 9, tab 115, This
Page
is
3835, yeah.
3835, thank you. This is the article by Judge Anthony Collins. He, as the footnote asterisk shows, he is a judge of the General Court of the Court of Justice. The General Court, of course, hears all the procurement cases that are brought against EU institutions where the same criteria apply. And the purpose of this relevant part of his article is to address the criteria for damages under the Remedies Directive. And at 3836, some 5 lines up from the bottom, he's referring to Speicher, as we see at the beginning of that paragraph. And he says the last sentence, the statement of law prompts 4 observations on the nature of damages remedy for breaches of the procurement rules. And over the page, 3837, can I pick it up in the middle of the page? Third, the requirements that the rule breach must be intended to confer rights on individuals and that the breach of such a rule must be sufficiently serious means that not every legal error in the course of an award procedure can ground an action in damages. And over the page, at the top of 3838, he repeats himself, thus not every error of law is a manifest and grave disregard, that of course is the meaning of sufficiently serious, of the limits upon a contracting authority's discretion, such as will ground a damages action. And at the end of that section, in the middle of the page, the paragraph in the middle of the page, by reason of the foregoing, it seems that whilst a decision to award a contract can at least in principle be set aside on the basis of any illegality in the procedure leading to its adoptions, damages are unavailable as a remedy for every breach of the procurement rules. Accordingly, damages are a supplementary remedy for breaches of the procurement rules. That's his view, and I rely on it. I say that it is correct. I do not accept there's any room for reasonable doubt. The Court of Justice has stated the position. A reference would be entirely unnecessary in these circumstances and inappropriate. My friend says to apply the factor-tame criteria would breach the principle of effectiveness. I can't accept that. The Court of Justice accepts that the factor-tame criteria are consistent with the principle of effectiveness.
Can I just ask, I mean, we haven't had Silfit cited to us.
No.
Referred to in the later case. But just reading Silfit, finally, the correct application of community law may be so obvious as to leave no scope for any reasonable doubt as to the manner in which the question raised is to be resolved. Before it comes to the conclusion that such is the case, the National Court or Tribunal must be convinced that the matter is equally obvious to the courts of the other member states and to the Court of Justice. Only if those conditions are satisfied may the National Court or Tribunal refrain from submitting the question to the Court of Justice and take upon itself the responsibility for resolving it. I mean, reading Professor Troimer, and he is a professor of procurement law at Copenhagen University, it appears, reading his article, it seems on the face of it far from clear that other member states have hoisted in what you say is the effect of European law according to Speicher.
Yeah, I take that point. I haven't read those judgments. The court doesn't have those judgments. But I say the test is not whether other courts have appreciated the effect of Speicher. The question is whether in the material there is any proper basis for doubting that if those other courts are directed to the relevant materials, they would have any doubt about the answer.
Presented with arguments by yourself or
No. But the court has to reach a view. I mean, the fact that it may be possible to point to a judgment in another European state cannot of itself create a reasonable basis for saying there is some doubt, some uncertainty, if none otherwise exists.
Those other cases were pre-Speicher, weren't they? In the Swedish Supreme Court. Was 2007.
Yes.
That's the trouble. We don't really have any
update
as to what they would have made. I mean,
yes.
Judge Collins seems to have thought that Speicher sort of settled in what had clearly been a rumbling on dispute, as we see from the second edition.
I make it very clear, my lord, I entirely accept, absent Speicher, this would be an issue that this court would no doubt wish to refer to the Court of Justice.
I suppose you can say that the very fact that this was an issue that was rumbling on and was out there makes it all the more significant that the Court of Justice said what they said in Spiker.
Yes, well, indeed so, my lord. Indeed. Indeed. My friend cannot gain any assistance from Article 2.7 of the Utilities Directive for two reasons. First of all, there's no equivalent provision to Article 2.7 in the Remedies Directive. And secondly, it's only concerned with wasted costs in any event. My friend did rely, and I dealt with this partly in opening, he did rely on the WTO materials. I made the point in opening that it's a limited damages liability, it's confined to wasted costs, but I also make the point, I don't want to go back to the materials unless the court wants me to, but it also specifically says that what is required are procedures for, quote, correction of the breach or compensation. So I don't even accept that there's a right to compensation sufficient, in my submission, to provide a procedure for a breach. And there's nothing in the WTO provisions that can override a Spiker, nor were the other cases are on point that my friend relied upon. That's what I want to say on the first point. And then we come to the national regulations. My friend's position is that the national regulations are unambiguous in his favour, and I say that is unsustainable. What Regulation 47J 2C provides is that the court has a power to award damages. It's not a duty, and it's not a duty even where there is a breach and damage has been suffered. And we respectfully agree with my Lord Sumption. We adopt the point my Lord put to my friend in argument. This means that the regulations necessarily envisage that there will be cases where damages are not awarded, even though damage has been suffered for a breach of the regulations. And my friend says, and I respectfully agree with him, this is not a discretion. There must be a principle that has to be identified, and he can identify no principle in this context. We say the evident principle is that the power must be exercised under the regulations to accord with the obligations of the United Kingdom under the directive which these regulations are implementing. And Regulation 47C, on which my friend founds, does not assist. It simply provides a precondition to a claim being actionable. The explanatory materials, we say, confirm our approach. My friend referred to Lord Nicholl's observations in Spath Holm. There has been much judicial analysis of the value of explanatory materials since Spath Holm. We referred to Lord Hope's speech in Montilla, which was Volume 5, Tab 59. But even Lord Nicholl's recognised the value of explanatory material on a confirmatory basis. And I would submit that the value of explanatory materials must depend very much on the context. In relation to domestic implementation of a European obligation through Section 2.2 of the European Communities Act, the courts have been prepared, and I say rightly so, to look at explanatory materials to identify not just the mischief, but the meaning of any ambiguous provision. My friend then emphasised that the domestic regulations have contained a damages provision since 1991, to which I respond that there's, as far as we're aware, there's been no explanatory material at any stage suggesting an intention to do more than transpose the EU obligation. But in any event, in 2009, the regulations made very significant changes to the remedies regime. And the court has seen those changes, in particular the standstill regime, and the impact that that had on the remedies available at the two stages, the stage of before the contract is entered into and the stage of after the contract is entered into. And regulations 47G through to 47N were new in 2009. Albeit the damages provision is similar to previous law. Now, those regulations, the 2009 regulations, were the subject of what the court saw, and I'm not going back to it, the explanatory note, the explanatory memorandum, the impact assessment, the transposition note. And as the Court of Appeal accepted, in all of that material, consultees and Parliament were assured that, subject to carefully identified exceptions, that the regulations were putting in place a remedies regime that went no further than the directive required. And I respectfully submit the court should take that firmly into account as at least confirmatory of the true meaning of these regulations. The final issue in the case, Mr. Howell says he has to say that so long as the claim is brought in time, there are no circumstances in which an unreasonable refusal to use the standstill procedure can affect the right to damages. And I say the true principle is it must depend on the facts. And that's what we want. We want the ability, the opportunity to be able to have the matter determined on the facts of this case. And it's not difficult to envisage circumstances where the conduct of the unsuccessful bidder is wholly unreasonable. I mean, suppose it knows all the facts, and suppose there is a short point in dispute between it and the public authority. And suppose the public authority says to the disappointed bidder, when they're having this dispute before the contract is entered into, that the standstill procedure will enable the matter to be determined at low cost, and the bidder still refuses to proceed under the standstill procedure and gives no reason.
Can you point to any case where a person has a choice of remedies against a defendant and is obliged to select one which is more helpful to the defendant?
I can only refer to the cases that I showed the court in opening, but my answer to your lordship's point, and I see the force of the point, I see the force of the point that my friend is making, that in general the law is very reluctant to impose an obligation on the claimant in this respect. But this is a regime, a remedies regime, that is brought into domestic law in order to implement a specific European obligation. And if I'm right on my earlier submissions, then I'm inviting the court to interpret the remedies regime under the regulations by reference to the contents of the directive and the general principles of EU law. And one of the principles of EU law, and can I just go back to it because it is so important to my argument, one of the principles of EU law is Volume 1, Tab 13, Brasserie du Pêcheur, paragraph 84, which appears at page 1146, Volume 1, Tab 13, page 1146, paragraph 84, and it's the statement by the Grand Chamber: in order to determine the loss or damage for which reparation may be granted, the National Court may inquire whether the injured person showed reasonable diligence in order to avoid the loss or damage or limited extent, and whether in particular he availed himself in time of all the legal remedies available to him. Now, that's the principle. And it's the principle of community law that can be applied by national courts. And I therefore don't accept in principle, if I'm right.
Well, does 84 have to be read with 85?
Yes. It's a general principle common to the legal systems that injured party must show reasonable diligence in limiting the extent of the loss or damage or risk having to bear the damage himself. But that must be read with 84. One can't take out of the equation the application of mitigation or causation. One can't take out, as my friend is contending, that it is in principle irrelevant whether the claimant has availed himself in time of all the legal remedies available to him.
What about 83? If there is a principle of the sort that Mr. Howell has identified, then we are imposing a greater obligation, as it were, on a potential claimant under this regulation than there would generally be in relation to claimants who have alternative claims.
Well, and the court would be doing it because these regulations are designed to implement EU law in this context, and the whole purpose of the regime here is to establish, most unusually, a special regime that the court has seen set out in the standstill procedures, which create a unique, so far as I'm aware, unique set of remedies that are made available, that if the claim form is issued, the contracting authority is obliged to stop. And it's obliged to stop precisely because the matter can easily then be taken to court for the court to determine whether or not it should allow the contracting authority to proceed to enter into the contract. That's 47G read with 47H. Yes, and it's also created by the contrast between 47I and 47J, that under 47I there is the power to set aside the decision or action concerned, but no such power once the contract has been entered into. And it has to be, and it is, the contention by my friend, which I submit is quite remarkable if the claimant has acted unreasonably, that it's entitled for no good reason to say, I'm not going to use the standstill procedures, I'm not going to stop the contract being entered into, I'm going to sit back, I'm going to sue for damages, I'm then not entitled to have the contract set aside, and I have a right because we're assuming that it can show there was a breach of the regulations, I have a right to claim damages for lost profits. I say that makes no sense whatsoever, particularly in the context of these regulations, and it makes no sense in the context of a directive which we are told, and the court has seen this, Alcatel, the case at Volume 2, Tab 15, the case that prompted the setting up of the standstill remedies, that the whole purpose of the regulations is to provide remedies at the earlier stage when, quote, infringements may still be rectified. So there's a policy here of seeking to encourage the availability of such remedies.
Can I just, this is probably not directly relevant, and we don't want to spend too much time on it, but just to understand how the process would work,
yes.
They could automatically have stopped you entering into the contract by issuing proceedings.
Yes.
You could then have gone to court,
yes.
And you presumably are saying you would have gone to court to be able to enter into the contract, and you would have been able to extract a cross-undertaking if they wished to continue the stay.
Well, no doubt a cross-undertaking would have been asked for, but the court may have said, we'll continue to stay without a cross-undertaking. Who knows?
Well, then, but you were very keen to enter into this contract, so much so you weren't even prepared to give 3 days delay without a cross-undertaking.
Well, we'd given more than the 10 days we were obliged to give. Your Lordship's right. We didn't want to give any longer.
But the cross-undertaking, would that have covered all loss going back to the date of the original stay? Because normally a cross-undertaking would cover future loss, wouldn't it?
It would.
So that, in truth, the scenario which you envisage is one which would actually have caused you loss over at least 3 days, which you weren't prepared to suffer by giving an extension.
Well, that would have been a matter for us.
This is all fact, really, you say?
It is. I can't make any submissions as to what would have happened. This is a matter would have to be investigated.
We'll have to look a bit further than this. I mean, the court almost as a matter of course requires a cross-undertaking in damages when it stops somebody doing something in the law. And the question I had was, would the cross-undertaking be expected to extend to the losses which the otherwise successful bidder would have suffered?
Well, that
seems to me probably yes.
Well, under 47H, the court is given a very broad discretion. This is truly a discretion.
It is a discretion, but it's a discretion which the court always has, but the court virtually invariably exercises in favour of granting.
Well, all of these factors would be material to the reasonableness of the conduct of the disappointed bidder, here the respondent. There's no material before the court to explain why it was not prepared to go to court and to the stay at that time.
If its case is right, it doesn't need to.
No, indeed, but there's no material that will assist.
No, it seems obvious that it must have been connected with the probable cross-undertaking.
Yeah.
Well, maybe.
Yes.
Anyway, but as you say, it's speculation, technically.
It is speculation. I say as a matter of principle. And my further answer to my Lord the President's question as to whether there is any case, it is not difficult to envisage cases where the court would say on a claim for damages, well, you're the author of your own misfortune. You haven't taken reasonable steps. And I would respectfully suggest that my Lord Mance's example is a very good one. That you see the neighbour's tree about to fall.
It hasn't fallen, though. You haven't suffered the damage. It's not quite the same thing. No wrong's been done.
It's about to fall. You know that the damage...
You can go for a queer Timet injunction, but that's all you can do.
Well, your Lordship says all you can do, but it's a very effective way of preventing the damage occurring. And the question...
Then maybe a causation issue.
The question is whether or not you're entitled to sit back. You're entitled to say, I have a choice of remedies, and the remedy...
You don't. You don't have a choice of remedies. That's not a choice case.
Yeah.
No one can say you've got to go off and get an injunction. You tell your neighbour the tree's about to fall down, do something about it.
Well, I say, given the context of these regulations, it's a very fine distinction.
Well, it would have thought the argument would be it's a question of causation. You not warning your neighbour, knowing that the tree was going to fall down, you may have been the author of your own misfortune, but I can't see it's a choice of remedies case.
No, well, I follow that. But here, one could say it's a matter of causation equally, that the claimant is suing us for lost profits.
I see that.
It's suing us for lost profits, and had it gone to court, had it obtained the standstill remedy, had the matter been adjudicated at that time, it wouldn't have suffered the lost profits. It would have got the contract. That's the point. And I invite the court to say, not to say never. It all depends. It all depends on reasonableness. That's how I put it, my lady. Those are the submissions.
Lord Hoffman gave rather an interesting speech. Never, never say never.
No, indeed.
Because of the requirement for certainty. But
it was a long-running dispute between himself and Lord Nichols.
Nichols, it was indeed, yes.
He was complaining about a decision where Lord Nichols had indeed said never.
I just argued the case, as well. Those are my submissions.
Thank you very much. Thank you, Lord Banning. Thank you.
Thank you, Lord.
Well, we're very grateful to both you, Lord Panic, and to you, Mr. Howell, for your submissions in this case, which have involved going through quite a lot of authority, and you've done it very attractively. Thank you both very much. Thank you also very much to everyone involved in preparing the written cases that we found very useful. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. The court's now adjourned.